Okay, we're back. Since we've got a bunch of guests today, Representative Sweeney, would you like to lead us in the pledge? Everybody could remain standing. I want to do a brief moment of silence for the turmoil that our country is going through. I think we all know what that's about. And my only statement on this will be, in America, we solve our problems and differences with ballots and not bullets. So we'll have a moment of silence. Thank you. We're going to start off with the notice non-germane hearing, which I'm introducing. So I'm going to go down there, and Representative Vice Chairman Quayle is going to take the gavel.
Thank you, Representative Berry. So we'll open the public hearing on HB 686 on a proposed non-germane amendment number 2025-2935H. And Representative Berry, who's drafted the amendment, can now tell us about it.
Okay, so this is revised language. This is the non-germane amendment from House Bill 686. I'm Representative Ross Berry, representing the towns of Ware and Goffstown. This is revised electioneering statute with working with the interested parties to try to get to some consensus language. So you're familiar with the bill. We've heard it multiple times now. The original is 340. But this is kind of a departure from its original form. So what it does is it removes out of RSA 659-44A, it removes the special definition for electioneering for a public employee, which was an intent-based definition. The current language says act in a way that is specifically designed to influence the vote of a voter on a candidate or measure. And this actually uses the stock definition that governs all of election law, which is found in RSA 652 16H. So we kind of have that provision that sits over all of Chapter 63, and instead of having a special definition for public employees, we're going to use the standard definition, which uses a reasonable person standard. So the original bill tried to list out everything. I was trying to list everything out, and the problem is when you do that, you either A, miss something, you overstep on something, but this brings it to a reasonable standard. So I'll just read the definition so we're all familiar with it. Electioneering means visibly displaying or audibly disseminating information that a reasonable person would believe explicitly advocates for or against any candidate, political party, or measure being voted. Electioneering includes, but not limited to, and the rest of it's kind of, it lists specific things. You can't hand out handbills, you can't wear stuff. So that's kind of less important. The original bill of 340 had a lot of those written out, but this actually makes the statute more concise and goes to a kind of a universal definition for electioneering. It also introduces a $1,000 fine, which is an addition, an alternative in some cases to the misdemeanor charge. So the last section, Section 3, specifically outlaws, which was the impetus for this, which are political surveys. The government should not be issuing any political survey to any candidate. I don't care what the survey says. The government's role is not to ask questions of candidates. That is the role of political parties, voters, interest groups. All of those people can ask questions. The government should be running the election in a neutral way and not participating and trying to put its finger on the scales. It's unnecessary and it undermines the process. So with that, I'm open to questions.
Okay, do we have questions from the committee? Looking, I don't. Oh, Representative Muirhead.
Thank you, Mr. Chair. And thank you for explaining your amendment, Representative Berry. I wanted to return to a concern that we discussed last winter. I know this is a highly refined and revised version of what might have been with 340, if I remember. And in Section 3, polls and surveys, we discussed last winter whether this would have the effect of limiting or even forbidding what the work that the UNH Survey Center does. I know that's not the intention. And here I see surveys that are political, comma, meaning that they are designed to favor one side or one candidate. So I'm assuming this is explicitly saying that a kind of neutral poll done by a polling organization at a university like UNH would not be political, even if it is surveying public opinion on, say, support for candidates who are running for governor or some other office.
Yes, that's my understanding as well. Because the language says that clearly indicate a preference for one or more candidates or political parties in an election, or one or more policies that are reasonably anticipated to be on a ballot or otherwise an issue in an election.
Thanks.
Do we have further questions from the committee? Yes, Representative Bay.
Thank you, Mr. Chair. Thank you for taking my question. This is it's about electioneering, and this is really a personal question for me. And this is with regard to the level of reasonability. Like, we're all reasonable people. Sometimes during elections, people are sort of on the edge. So I want to make this. This is for me the litmus test of how this is going to work. So I have for my first campaign, and before that, because my name is Luz Bay, it's nice on logo, and so I have made this T-shirt. It says "Ask me about Luz Bay." Now, is that if one wears that during election time, is that electioneering? Even though this is not necessarily campaigning, because my friends wear this in Hawaii. My friends wear this during non-election years. Somebody just asked me for a sweatshirt, and I gave it. So if someone is actually wearing it, it just says, "Ask me about Luz Bay." It doesn't say, "Vote for Luz Bay." Is that electioneering?
So I will answer the question. I'm going to back up a little bit. We're talking about public employees while they're in the commission of their official duties, right? So there's a difference between, let's say your police chief really likes you, right?
Yeah.
I'm assuming your police chief's a male. I'm just gonna, I don't know, I'm gonna assume. If he wears that, ask me about Luz Bay in his personal time while he's doing whatever, while he's shopping at Hannaford's, he can do that. He's actually protected. I believe it's RSA 98A protects public employees' freedom of speech when they're not doing their job. So that's fine. He can election. I would consider, the answer to your question is, I would consider it electioneering. But he has a right to electioneer when he's not on the public time, when he's not using his official capacity. What he couldn't do is roll up to the police station in his cruiser and then get out and begin being the police chief and arresting people wearing a "Ask Me About Luz Bay" shirt. So public employees can do whatever they want when they're not on the taxpayer time. They can do whatever they want when they're not using taxpayer resources. They don't lose their First Amendment rights by becoming public employees. But when they are on taxpayer time, when they are in their official capacity, or they are using taxpayer resources, then no, they can't electioneer.
Representative Gill.
Grill. Close.
so-
You were
I'm
close.
sorry.
Could this be applied to like novelty items? For example, a shirt saying "Vote for Pedro" from the movie Napoleon Dynamite. Would an employee be allowed to wear that?
No. They could, because it's not that person's not up. So the definition of, you got to go back to the definition of electioneering, and it says measure being candidate, political party, or measure being voted. So it's not being voted on. So yeah, they could wear that. I wouldn't, but they certainly could.
Representative Guzovsky.
One question that came up from the original bill and how it was presented, maybe you can address this now also. People were concerned at town deliberative if the fire chief was to get up and say, "Hey, we need a new fire truck," or whatever. Can you address that?
Yeah, and we actually on that bill, which got vetoed because it had an attachment. We attached language to allow, it was kind of clunky, but we attached language to allow the answering of questions. That's why I actually prefer the reasonable person standard here. Because if you ask the police chief why he needs a new cruiser, and he says, well, I need a new cruiser because the current one's 20 years old, right? I don't believe a reasonable person would infer that as electioneering. There's obviously, when you use the reasonable person standard, there's some grayness. For me, if the police chief went on to the town's Facebook page, official Facebook page for the police department, and said, go vote for Article 23, right? That for me crosses a line. And that's where I think the reasonable person standard really is useful, is I think it will allow the public officials who need to address certain issues that they're dealing with to deal with them appropriately, but will stop them from blatant advocacy. And there's a difference. It's called functional equivalent advocacy. There's a fine line, and I personally don't like using the reasonable personal standards on most things, but I think this is a situation where you actually have to use it.
Representative Muirhead.
Thank you, Mr. Chair. Just to follow up on that, Representative Barry, the reasonable person standard in 652.16H says that electioneering means visibly displaying or disseminating information that a reasonable person would believe explicitly advocates for or against any candidate, political party, or measure being voted. So if a town meeting is voting on a measure to fund a new fire truck, and the fire chief says, I advocate that you vote for this measure, then I think a reasonable person would have to conclude that this public employee is advocating for a measure that's being voted on, and thus would run afoul of this.
Yeah, and there's certainly going to be, I think, a fine line in how they're going to have to tread carefully with how they address this. But by the way, they should be treading carefully with how they address this, right? Because they are using taxpayer resources to influence an election. So, I think there's going to be some sussing out of this. The nice part about this statute is only the AG can bring forward the complaints. A private person cannot bring forward a charge on this. So there's going to be multiple safeguards in there, right? I doubt the DOJ is going to prosecute a fire chief for saying we need a new fire truck. I would hope the DOJ would prosecute a fire chief who puts a candidate's banner across a publicly owned fire truck, right? There's a line. And at some point, someone's going to have to make a decision, but I don't think you can suss it out in words, which is why you use the reasonable person standard.
Do we have further questions from the committee? I'm not seeing any, so thank you, Representative Berry. Okay. Well, thank you for the introduction to your amendment and the explanations. Now we have so far 2 individuals wishing to testify. The first one in was from Ms. Olivia Zink. And thank you for being here today and sharing your thoughts with us.
Thank you. Good morning, Chairman and the members of the Election Law Committee. For the record, my name is Olivia Zink, Executive Director of Open Democracy, a nonpartisan nonprofit, and here today to testify in opposition of the non-germane amendment. The reason this amendment has been unpopular. First, the other body killed this bill. Then it was amended to a bill and the governor vetoed it. So this is the 3rd attempt. Currently, our law is fine. It really protects public employees from using their time to electioneer. Our current law is okay. We don't need additional things. This amendment originated against a lawsuit with the Goffstown Public Library publishing a candidate survey, which the Superior Court judge dismissed. But they said that the library staff cannot electioneer. So it's important for us to not change the laws for a single one dispute. This is a larger issue about the freedom of speech of our people that work in our communities. And we really need to ensure that our public officials are not using their time, whether it's the town clerk or the fire chief or the teacher or the librarian, shouldn't be using paid time to electioneer. Should be prohibited. And we should make sure that our current law is enforced. Therefore, I urge you to ITL House Bill 686 as this non-germane amendment has, because it silences public employees and sets dangerous precedents, limits open dialogues, and undermines New Hampshire's civic participation traditions. Happy to take any questions.
Okay, thank you. Before we proceed with questions, if any, I noted on your pink card that judging by your testimony, you mistakenly checked off you support this.
Oh, sorry.
So with your permission, we will fix that.
Yes, thank you.
Okay.
Do you want these handed around, or?
Sure. Start them off there. Yep. And you said you'd take questions. Do we have any questions from the committee? I don't see any. So thank you very much for testifying today. Okay. Next pink card I have is from Sarah Burke Cohen. Thank you very much for being here today.
Let me try that again. Good morning, everyone. My name is Sarah Burke Cohen. I represent the New Hampshire Municipal Association. We oppose this non-germane amendment to HB 686. It expands the definition of who is covered by electioneering to include public employees who are appointed by the executive, the CEO, the chief executive or legislative body. This is going to muzzle people that are directly involved with policy development, planning, and whose positions are tied to this, and public outreach. Public employees in these appointed positions are experts generally, and we strongly believe that this will prevent them and restrict them from actually offering their opinion on whether they need a new fire truck or not. We think that this will, in fact, be considered electioneering. And even though the Attorney General's office is going to be the one that enforces it, it's still a complaint that's filed against this individual that the municipality has to undertake and participate in and spend its resources in defending, all because this expert is being told they are electioneering for just doing their job. We think that the definition in this non-germane amendment, because it restricts this speech, is going to chill speech by these experts and by other public employees who will be unwilling to speak up about different initiatives where they could have information, but that could be taken as being a reasonable person could take as trying to influence them or trying to, be for or against something. The other thing to consider in this is there is a significant amount of vague language, including expressly or primarily political, clearly indicate a preference, reasonably anticipated to be on a ballot. This subjective and overly broad language could lead to selective or retaliatory enforcement because of political agendas. Again, it means that municipalities will be having to defend defend anything that could be considered just government, their work, their public, what they're supposed to be doing in their public positions. Finally, certainly we have an issue with the component about surveys. There are some municipalities that use surveys to gather information. Because of the vagueness of the language, that could prevent them from doing a survey. Because it's so subjective, anyone could think that this is something that's political when they're just trying to research something that may or may not be on the ballot, because the language is reasonably anticipated to be on the ballot. Will a traffic circle, whether a traffic circle be put in on the ballot or not, it's unclear, and so they can't gather that information from the public without fear of being charged with electioneering. Again, it would be a complaint that the AG's office would enforce. However, it's still the municipality that has to participate in this and use its resources to put forward to defend it. So the bottom line is, we think this bill is going to blur the line between legitimate government work that our experts are doing and our public employees are doing, and political speech, and used as a way to really silence any other non-dominant opinion. So with that, I will tell you we oppose the non-germane amendment to HB 686, and I'm certainly open for questions.
Okay, thank you very much for your testimony. Do we have questions from the committee? I do not see any, so thank you very much. At this point, I've had 2 requests for public testimony. I don't see any others. And so that being the case, and I'm not seeing anyone rushing forward, so that being the case, I will now close the public hearing for HB 686 and the non-germane amendment related to that. The hearing is now closed. Representative Bay, could you please retrieve the blue sheet for me? Thank you so much. And on this, I see 2 individuals have indicated that they are opposed to this amendment. Okay. The hearing is closed. We're ready at this point to proceed with the executive sessions. Is our chairman here somewhere? I'm sure he is. Oh, okay. Thank you for reminding me of that, Representative Muirhead. We are going to, I'm going to open the executive session for CACR 4 and then immediately recess it so that our minority component can caucus and discuss what they have to discuss. So I am opening CACR 4. It's open, and I am now recessing it. We'll resume. How long do you need, Representative Muirhead?
If we could have 15 minutes.
All right, we will reconvene in 15 minutes, which would be, according to my watch, 10:36.
Thank you, Mr. Chair.
Thank you. We are in recess.
Okay. Well done.
if members could start taking their seats, and we're got some in the hall, if somebody could just pop in the hall and say hey. Okay. I believe the vice chair opened up the executive session, right? So we're already in executive session?
Yes.
Correct. Okay. We'll open up the notice executive session for CACR 4 relative to voting eligibility, providing that only legal resident citizens who are at least 18 years or older who reside in the place they claim as domicile shall be eligible to vote. I will make the motion of ought to pass. Is there a second?
Seconded.
There's a second. I will move amendment 2025-2937H. Is there a second?
Second.
All right, we are now on discussion of the amendment. I will explain the amendment. The amendment removes the citizenship portion of the CACR, so it just becomes a issue of residency. So we'll handle the citizenship part later on, not this session, but we don't need to put the two together. So is there further discussion on the amendment 2025-2937H? Representative Muirhead, you recognized.
Thank you, Mr. Chair. I just note in brief that though the amendment moves the CACR, I think, in a better direction, in an effort to clarify what it means to be a resident, I think that the language of the amendment and the language of the underlying CACR actually would introduce new ambiguities into the Constitution. In particular, the phrase "actually reside" isn't defined, and I think will be problematic and ambiguous. And for that reason, I regret that I'm going to have to oppose the amendment.
Is there further discussion on the amendment? Representative Newsom.
Thank you. I agree with my colleague with that actually residing in place they claim as domicile could have unintended consequences regarding all absentees, but especially UOCAVA voters. And I know it's not the intent of this, but the term legal resident thrown in there, to me, like flagged out as green card holders are legal residents. And I know you're not trying to get them to be franchised, but I think it's just problematic there as well. Thanks.
Further discussions on the amendment? Seeing none, Representative Mira, do you have any objection to a voice vote, or would you like a recorded vote on the amendment, not the underlying bill?
I have no objection.
All right, we are allowed to adopt amendments by a voice vote. All in favor of adopting the amendment say aye. Aye. All opposed say nay. Nay. In the opinion of the chair, the ayes have it. I will now move ought to pass as amended on CACR 4 with amendment 2025-2937H. Is there a second?
Second.
There is a second. We are now on discussion of the bill as amended. Is there discussion on the bill as amended? Hearing none, when the clerk is ready, the clerk will call the roll on the motion of ought to pass as amended on CACR 4 with amendment 2025-2937H.
Vice Chairman Quayle,
Yes.
Representative Perdomo Bryan.
Yes.
Clerk says yes. Representative Wary.
Yes.
Representative Wood.
Yes.
Representative C.
Yes.
Representative Gazowski.
Yes.
Representative Sweeney.
Yes.
Representative Moffett.
Yes.
Representative Muirhead.
No.
Representative Ward.
No.
Representative Gilmore. Did I not have? Oh, so sorry. Nope. You're subbing for. Okay, I actually. My apologies. I knew this was going to be a. Sorry, I had the wrong person in the wrong place. So my apologies. Okay, Representative. Well. Let me go back here. Where are we? We got Ward. Okay, Representative Bay.
No.
Representative Grill.
No.
Representative Wilhelm.
No.
Representative Newsom.
No.
Representative Seibert.
No.
And Chairman Barry.
Chair votes yes. The motion of ought to pass as amended on CACR 4 with Amendment 2025-2937H carries on a vote of 10 to 7. I'll be responsible for the majority report. Representative Muirhead, who will be responsible for the minority report?
I will, Mr. Chair.
Thank you. We will close the executive session on CACR 4. Representative, is it Seibert or Siebert? I'm sorry. We don't want to mispronounce your name.
Actually Seibert, but
Okay.
if you forgot it.
We don't want to forget. I apologize. We were debating that earlier, and I figured we'd just ask. Okay. We will open up the executive session for HB 158 relative to public inspection of the absentee ballot list, and I will recognize Representative excuse me, Weary for a motion.
Make a motion of ought to pass.
There's a motion of ought to pass. Is there a second?
Second.
Representative Wood seconds. Are there any amendments to be moved, Representative Weary?
No, sir.
Okay. We're on the motion of ought to pass. Is there any discussion on the motion of ought to pass? Hearing none, the clerk will call the roll on the motion of ought to pass on House Bill 158.
My apologies. My information was incorrect, so I have to readdress everything. Vice Chairman Quayle.
Yes.
Representative Pudum O'Brien.
Yes.
Clerk says yes. Representative Wary.
Yes.
Representative Wood.
Yes.
Representative C.
Yes.
Representative Gozowski.
Yes.
Representative Sweeney.
Yes.
Representative Moffett.
Yes.
Representative Muirhead.
No.
Representative Ward.
No.
Representative Bay.
No.
Representative Grill.
No.
Representative Wilhelm.
No.
Representative Newsom.
No.
Representative Seibert.
No.
Chairman Barry.
Chair votes yes. The motion of ought to pass carries on a vote of 10 to 7. Representative Weary, you'll be responsible for the majority report. Representative Muirhead, who will be responsible for the minority report? We will close the executive session on House Bill 158. We will open the executive session on House Bill 281, requiring electronic voter checklist to be supplied in a sortable. Excuse me, the asthma is bad today because of the allergies. Requiring electronic voter checklist to be supplied in a supportable format. Representative Weary, you're recognized for a motion.
Like to make a motion of ought to pass.
Representative Weary moves ought to pass on House Bill 281. Is there a second?
Second.
Representative Wood seconds. Representative Weary, are there any amendments?
Yes, Mr. Chair, we have amendment 2025-2939H, and all the members should have a copy of that.
All right. Representative Weary moves Amendment 2025-2939H to House Bill 281. Is there a second?
Second.
Representative Wood seconds. We're now in discussion of the amendment. Is there discussion on the amendment? Representative Weary is recognized.
From the original public hearing on House Bill 281, there are some good comments regarding clarifying the format for this sortable spreadsheet. And in addition, there was a request regarding the voter address. if it was sent to an address, or the sending address, if it was sent to a address different from where the voter is currently registered. And the language that was originally proposed in House Bill 281 was a little vague and unclear, so that has been revised and made more clear, and hopefully that's an improvement.
Is there further discussion on Amendment 2025-2939H to House Bill 281? Representative Seibert.
Yeah, about the whole bill and everything in the amendment, but I just want to, because I had this problem too, actually, and I know it was a few years back or whatever. I don't remember the exact year when it wasn't being made available in the format, but then in 22, I went to my clerk's office and was like, I need it in the sortable format, and it was actually required as of 22, and it was in their manual that's given to them by the Secretary of State. It's actually mentioned 4 times, and it also mentions the where, you know, they have to give all of the data along with it, including for the absentee ballots and including the party affiliation and all that stuff, and where it was sent and all that fun stuff and the dates. And it's mentioned 4 different times too, by the way. So I printed it off if anybody would like to see it. And this is directly from the clerk's, the handbook, the voting manual, and it has the RSAs to reference to. But I mean, I agree with it. I'm like, for time's sake, you know, it was already a law in the books. So thank you.
We'll have to talk to the representative that worked hard to make those the laws. It was me. Is there further discussion on the amendment? Hearing none, the clerk, Representative Muirhead, do you have any objection to voting on the amendment by voice vote?
Thank you. I do not.
Okay. We're voting on Amendment 2025-2939H to House Bill 281. All in favor of adopting the amendment say aye.
Aye.
All opposed say no. In the ears of the chair, the ayes have it. The amendment is adopted. Representative Weary is recognized for a motion.
I'd like to make a motion that House Bill 281, as amended, ought to pass as amended.
Representative Weary moves ought to pass as amended on House Bill 281 with Amendment 2025-2939H. Is there a second? Representative Weary seconds the motion. We're now in discussion of the motion of ought to pass as amendment on House Bill 281 with Amendment 2025-2939H. Is there discussion? Representative Wilhelm?
Chairman, you mentioned that you worked on these bills and passing them into law. So are these already in statute, or are they not?
No, this part is not.
Okay.
No. And it was not a solo effort, just so we're aware. I believe there was some bipartisan support on that.
It never is.
Further discussion on the motion of ought to pass as amended on House Bill 281? Go for it.
I heard you say Representative Woods seconded it.
No, oh, sorry, Representative Wood seconded. I apologize. He obviously can't second his own amendment. Representative Wood seconded it. All right. When the clerk, hearing no further discussion, the clerk will call the roll on the motion of ought to pass as amended on House Bill 281 with Amendment 2025-2939H.
Vice Chair Quayle.
Yes.
Representative Pudeau-O'Brien.
Yes.
Clerk says yes. Representative Weary.
Yes?
Representative Wood.
Yes.
Representative C.
Yes.
Representative Gozowski.
Yes.
Representative Sweeney.
Yes.
Representative Moffett.
Yes.
Representative Muirhead.
Yes.
Representative Ward.
Yes.
Representative Bay.
Yes.
Representative Grill.
Yes.
Representative Wilhelm.
Yes.
Representative Newsom.
Yes.
Representative Seibert.
Yes.
Chairman Barry.
Chair votes yes. The motion of ought to pass as amended on House Bill 281 with Amendment 2025-2939H carries on a vote of 17-0. Is there any objection to this bill being placed on the consent calendar? Hearing no objection, the bill will be placed on consent calendar. We'll close the executive session on House Bill 281, and we will open the executive session on House Bill 289 regarding domicile qualifications for voting. Representative Weary is recognized on behalf of the subcommittee.
Thank you, Mr. Chair. The subcommittee reviewed House Bill 289 at the time. We made a recommendation to retain that, and that was in the report that was submitted to the chair and vice chair, And at this point, that was the recommendation out of the subcommittee. I have an additional recommendation for the purposes of this executive session.
So what is your motion, Representative Wade?
I'd like to make a motion of inexpedient to legislate.
Is there a second on the motion of inexpedient to legislate? Representative Wood seconds. We're now in discussion of the motion of inexpedient to legislate on House Bill 289. Is there discussion on the motion? Hearing none, when the clerk is ready, the clerk will call the roll on the motion of inexpedient to legislate on House Bill 289.
Just catching up. Vice Chairman Quayle.
Yes.
Representative Perdomo O'Brien.
Yes.
Clerk says yes. Representative Wary.
Yes.
Representative Wood.
Yes.
Representative C.
Yes.
Representative Gosowski.
Yes.
Representative Sweeney.
Yes.
Representative Moffett.
Yes.
Representative Muirhead.
Yes.
Representative Ward.
Yes.
Well, I'm sorry, Ward. I missed that. Yes, okay, thank you. Representative Bay.
Yes.
Representative Grill.
Yes.
Representative Wilhelm.
Yes.
Representative Newsom.
Yes.
Representative Seibert.
Yes.
Chairman Barry.
Chair votes yes. The vote of inexpedient to legislate on House Bill 289 carries on a vote of 17-0. Representative Weary, you will be responsible for the majority report. Is there any objection to House Bill 289 being placed on the consent calendar? Hearing none, House Bill 289 will be placed on the consent calendar, closing the executive session on House Bill 289. We're going to open the executive session for House Bill 317, preventing a supervisor with a checklist from verifying a person's identity without identification, even if they personally know that person. And I will recognize Representative Perdomo O'Brien for a motion.
I move ought to pass.
Is there a second?
Second.
Representative Gosowski seconds. We're on the motion of ought to pass on House Bill 317. Is there discussion on the motion of ought to pass? Representative Perdomo O'Brien would like to speak to your motion.
Yes, I am aware that it may lead to some memorable moments at the polling place when people who are known to the supervisor of the checklist are asked to prove their identity, such as their own parent or child or spouse. But I think this will increase voter confidence when there's never a time when a voter is not asked to show their identity. That will increase voter confidence because the relationship between these people is not always known to observers.
Is there further discussion on the motion of ought to pass on House Bill 317? Hearing no further discussion, the clerk will call the roll on the motion of ought to pass on House Bill 317.
Vice Chairman Quayle.
Yes.
Representative Perdomo O'Brien.
Yes.
Clerk says yes. Representative Wary.
Yes.
Representative Wood.
Yes.
Representative C.
Yes.
Representative Gosowski.
Yes.
Representative Sweeney.
Yes.
Representative Moffett.
Yes.
Representative Muirhead.
No.
Representative Ward.
No.
Representative Bay.
No.
Representative Brill.
No.
Representative Wilhelm.
No.
Representative Newsom.
No.
Representative Seibert.
No.
Chair Barry.
Chair votes yes. The motion of ought to pass carries on a vote of 10-7. Representative Perdomo O'Brien, you'll be responsible for the majority report. Representative Muirhead, who will be responsible for the minority report?
Representative Ward.
Representative Ward, you'll be responsible for minority report. I'm going to close the executive session on House Bill 317. I'm going to open the executive session on House Bill 323, requiring the presentation of government-issued photographic means of identification in order to vote. We will recognize Representative Weary for the purpose of giving the subcommittee report.
Thank you, Mr. Chair. The subcommittee reviewed the bill and at that time made a motion to retain the bill, and subsequent to that, I believe Representative Wood has a motion for today's executive session.
Okay. Representative Wood is recognized for a motion.
Yes, I'd like to move House Bill 323 OTP to pass.
Okay.
Move it to
Representative-
the floor, actually. We're gonna, we have a.
You have an amendment?
We have an amendment.
I believe
sorry.
I have the amendment.
You have an amendment, sorry.
Representative Wood moves ought to pass is there on House Bill 323. Is there a second?
Second.
Representative Gosofsky seconds. I will make the motion to move Amendment 2025-2940H to House Bill 323. Is there a second?
I'll second it.
Representative Gosofsky seconds. I'll explain the amendment. So the amendment keeps, the amendment basically restores the ability to use an out-of-state driver's license for the purpose of identification. So the reason I want to put that back in is there's a case, Casey v. Gardner, that discusses kind of the peripherals of this, of forcing the use of an in-state ID. You have to remember that when people are registering to vote, they have to do the acid test, right? Age, citizenship, identification, and domicile. So when you get rid of the in-state ID, as much as kind of conceptually I like the idea, you do risk, I think, unnecessarily running afoul of court decisions. And because the bill does not have any severability built into it, you can actually risk losing the whole bill. So we still have the domicile portion in here. That's still a part of this. So if they're not using an in-state ID, guess what they have to bring? They have to bring other documents that show that they live where they say they live. So we're not getting rid of that. But that's the purpose of the amendment. So we're now on further discussion of the amendment. Is there further discussion? Representative Newsom.
Could you say that again about your comments about proving domicile? Because this is about obtaining a ballot where all you have to do is prove who you are, correct?
Correct. Yeah, that's my issue is you have to allow people to use the courts have said, I disagree with it. Let me be very clear. But my interpretation of Casey v. Gardner is you cannot disallow specifically an out-of-state ID. And my point about the proving yourself you are is to kind of calm the nerves of people who think that we're not making you prove that you live in New Hampshire. That requirement is still intact.
At time of registration, not time of obtaining the ballot, though.
Well, when you obtain a ballot, the only thing you have to prove is ID.
Correct.
Yes.
Thank you.
Is there any further discussion on the amendment? Representative Muirhead, are you comfortable with a voice vote on the amendment, or would you like a recorded vote?
I'm comfortable with a voice vote.
Okay. All in favor of adopting Amendment 2025-2940H, say aye.
Aye.
All opposed, say no.
Nay.
In the opinion of the chair, the ayes have it. Representative Wood is recognized for a motion.
Yes, I do want to make a statement and a motion to move House Bill 323 amended to the floor, please.
Representative Wood moves ought to pass as amended on House Bill 323 with Amendment 2025-2940H. Is there a second?
Second.
Representative Gosofsky seconds the motion. We're now on the discussion of the motion of ought to pass on House Bill 323 with Amendment 2025-2940H. Is there discussion on the motion of ought to pass as amended? Representative Wood is recognized.
Yeah, I have some constituents that were pressed me to move this bill forward. They asked me to make a statement in their behalf. So there's a combination of several discussions. Item 1, election security and integrity. Government photo ID is the standard to safeguard against voter impersonation or double voting. Government issue IDs are legally recognized because they're backed by official records and only issued after a thorough identity verification process, e.g. birth certificate, social security numbers, proofs of residency, etc. Consistent with everyday transactions, universally accepted. Government photo IDs are already required for many routine activities, boarding a plane, buying alcohol, opening a bank account. So it seems reasonable to require one for something as important as voting. And the last item brought to my attention was student photo IDs don't come close to the same standard of government photo IDs are based on enrollment records only. I will close with that. Thank you.
Is there further discussion on the motion to vote to pass as amended on House Bill 323? Representative Muirhead, to recognize.
My concern is that this bill, thank you very much, Mr. Chair. My concern is that this bill would unintentionally disenfranchise, especially different categories of citizens, including students who reside in the state and who don't have driver's licenses and rely on their student IDs to prove their identity when they vote. Sorry, what's that?
I'm sorry, the vice chair was asking a question.
Oh, sorry. I mean, in the olden days when I was at Central High School in Manchester, New Hampshire, any number of my classmates didn't get driver's licenses. Insuring an 18-year-old is an expensive proposition for a family. Not all families can afford to do that. They might graduate. Many of my classmates who graduated from Central went on to UNH, or Plymouth, or Keene, and they still didn't have driver's licenses. They didn't particularly need a driver's license in Durham or Keene once they were dropped off for the term. And it wasn't until they got jobs that they could afford, to insure themselves as drivers that they got a driver's license and could afford a car. So I'm concerned about those citizens being disenfranchised unintentionally by this.
Is there further discussion on the, yes, Representative Newsom?
Thank you. During the hearing for this bill, originally we heard of 0 instances of fraud under the classes of IDs that are being removed from the list. So it's not a fraud problem in the reality of what's happening at the polls. What this will have undoubtedly is a lawsuit from someone who does not have a driver's license, but will be prevented from voting, I should say. And that'll go through the court system and end up costing the state about $1.5 million to defend that case. The original bill had broad public opposition. My notes show that it was 48 to 735 that were opposed to this concept of removing these. And lastly, I would note that there's an argument to be made that the list is merely types of IDs that shall satisfy the requirements. So there's an argument to be made that it's not an exclusive list, so we're not really changing anything at all. So that is all I have to say. Thanks.
Is there further discussion on the motion to vote to pass as amended? I guess to be witty, Representative Newsom, if the list is not all encompassing, then you can support it and we can just, it's fine. It was a little tongue in cheek there. My issue with this is that I am supporting the motion about to pass as amended. Is we're taking these from places that we pick and choose for some reason. I don't see SNH on here. I don't know why, but the reality is when you go to vote, it needs to be a government issued ID. I do not consider an ID issued by a university, a private high school to be a government issued ID. We need to go to a standardized system of just taking government issued IDs only, and I support that. So if anyone wants to refute that statement, they're more than welcome to, and then we're going to move. Representative Prima Bryant.
Thank you. I think those are interesting comments, and I appreciate what the other side has said on this. But I think back to times when I have helped some elderly family members who did not drive anymore obtain IDs so that they could obtain government services, and it was only $10. Is that correct for a non? Is that? I think it's only $10 to get a non-driver ID, state-issued ID. So I don't consider this to be too much of a hurdle, and it's something that young people can afford as well.
I think another thing that we should look at, because you can get you can get a identification card, and I think we should look at, it's only $10. I think we should look at making it $0. And if anyone wants to bring that forward, I'm happy to co-sponsor that. Representative Muirhead.
Thank you for calling me again, Mr. Chair. I appreciate that. And where I live in the Upper Valley now, the closest DMV is, I think, in Newport, there's no public transportation to Newport. If you don't have a car and you don't have a driver's license, getting to that DMV is really difficult. Increasingly, you have to make an appointment to get there, and so you have to plan ahead and get somebody to drive you. It's hours out of a work day to get there. I think if we're going to be relying on these exclusively, then we should ask the DMV to go into schools and offer these IDs for free to citizens when they turn 18, and really facilitate the distribution of these non-driver's IDs to every citizen in the state. It's really hard to get into a DMV. I mean, it's really absurd. And if the DMV is there somebody here from the DMV, I'd really be grateful if you would open an office in Lebanon, New Hampshire.
Actually, I'm reading the statute now, so it's $10 right now. It's going to go to $20. However, I think I may have spoken too soon. A person who requires a photo identification card for voter identification purposes may obtain a voucher in the form provided in subparagraph B from his or her town or city clerk or the Secretary of State, exempting the voter from the identification card fee. So it's already free. So my apologies. It's already free. And upon presentation of the voucher to the division, the purpose of the card shall be stated and marked as voter identification only. So my apologies, it is already free. It's not $10, it's not $20, it is currently free. Representative Wilhelm.
And yet it's also not widely known, right, that it's free. And so it seems like some voter education, especially with so many changes in election law over the last several years, might be in order as well.
I would support that as well. Representative Bank.
I just want to clarify a comment that you made. So if a student going to a state university has a student ID, that is not considered government ID.
No, I don't consider that government ID because has anyone from UNH testified to what they do when they give you that ID? Do they check a birth certificate? Like they bring a social security card? Are they presenting anything else when they're giving that? Also, student IDs are inherently insecure. You could print one off of a card reader. It's very easy to do. So we're going to go to, in my opinion, we're going to go to government-issued secure IDs only. Is there further discussion, or are we ready to move on? All right. Hearing no further discussion, the clerk will call the roll on the motion of ought to pass as amended on House Bill 323 with Amendment 2025-2940H.
Thank you for that extra time. I was able to catch up on the order. Vice Chairman Quayle.
Yes.
Representative Pujomo Bryan.
Yes.
Clerk says yes. Representative Wary.
Yes.
Representative Wood.
Yes.
Representative C.
Yes.
Representative Gozowski.
Yes.
Representative Sweeney.
Yes.
Representative Representative Moffett.
Yes.
Representative Muirhead.
No.
Representative Ward.
No.
Representative Bay.
No.
Representative Grill.
No.
Representative Wilhelm.
No.
Representative Newsom.
No.
Representative Seibert.
No.
Chairman Barry.
Chair votes yes. The motion of ought to pass as amended with Amendment 2940H to House Bill 323 carries on a vote of 10-7. Representative Pujomo Bryan, you'll be responsible for the majority report. I'm sorry, not Representative Pujomo Bryan. My apologies. Yeah, it's all right. Representative Wood, you'll be responsible for the majority report. Representative Muirhead, who will be responsible for the minority report?
Representative Newsom.
Representative Newsom will be responsible for the minority report. We will close the spirited debate and discussion on House Bill 323, and we will open up House Bill 340, the executive session for House Bill 341, requiring the Secretary of State to check records prior to every election. Representative Ward, would you like to make a motion?
Sure, I'd like to move ITL.
Representative Ward moves inexpedient to legislate on House Bill 341. I will second the motion. Is there any discussion on the motion of inexpedient to legislate on House Bill 341?
I just had one comment.
Oh, yeah, absolutely. Go ahead.
Sponsor, other unnecessary legislation has made this bill redundant and obsolete. And I should also point out that the tagline associated with it from the beginning is incorrect.
Fair enough. Is there further discussion on the motion of inexpedient to legislate on House Bill 341 FN? Hearing none, the clerk will call the roll on the motion of inexpedient to legislate on House Bill 341.
Vice Chairman Quayle.
Yes.
Representative Perdomo O'Brien.
Yes.
Clerk says yes. Representative Wary.
Yes.
Representative Wood.
Yes.
Representative C.
Yes.
Representative Gozowski.
Yes.
Representative Sweeney.
Yes.
Representative Moffett.
Yes.
Representative Muirhead.
Yes.
Representative Ward.
Yes.
Representative Bay.
Yes.
Representative Grill.
Yes.
Representative Wilhelm.
Yes.
Representative Newsom.
Yes.
Representative Seibert.
Yes.
Chairman Barry.
Chair votes yes. The motion of inexpedient to legislate carries on a vote of 17-0. Representative Ward, are you good with the majority report? All right, Representative Ward will be responsible for the majority report. Is there any objections to the bill being placed on the consent calendar? Hearing no objections, the bill will be placed on the consent calendar. We will close the executive session for House Bill 341. Open the executive session for House Bill 463 relative to the compensation of Board of Recount and Elections for the Select Board and for the School Board. And I recognize Representative Weary for a motion.
I'd like to make a motion of ought to pass.
Representative Weary moves ought to pass on House Bill 463. Is there a second?
I'll second.
I'm sorry, Representative Gosowski seconds. There's no amendments on this one. No. Is there discussion on the motion? Is there further discussion? Is there discussion on the motion of ought to pass on House Bill 463? Representative Weary, you're recognized.
We had retained this bill earlier, and after deliberation, we're going to move it forward.
All right. Is there further discussion on the motion of ought to pass on House Bill 463? Representative Newsom, you're recognized.
Thank you. My concern on this one is when the school board members are called to do the Board of Recount for a town election where you have a multi-town school board. You may not have the adequate people within that town, or you'd be asking people from a different town to come in and do that recount, and that I think is a problem.
It's honestly, I can't think. I can't say that that's entirely an invalid point. I think you're at this point we're choosing between the lesser, right? So it's either you have candidates who are potentially recounting their own race.
Oh, I have no problem with them not recounting their own race.
Yeah. I know. I'm sorry. I wasn't.
That's a great change.
I didn't mean to infer that. I apologize if that's how you took it. That was certainly not my intent.
Right. No, I understand. Thank you.
My point is this: there's no great solution here. But Representative Weary.
If I'm not mistaken, I believe the moderator for that election can appoint people to step in and serve in that capacity. So I think if there's a deficiency in the number of people necessary to count that, there are provisions that could make, I'm not sure if it's in this exact bill, but I think there are provisions elsewhere.
Yep, absolutely.
Are there also provisions to prohibit somebody from a different town from being on that Board of Recount? Because I think this would allow that.
I don't know, but a floor amendment might be in order. Like I said, I think these are very valid. I think these are very valid points. So otherwise, I wouldn't have said such.
Happens every now and again.
Happens every now. I believe you. I believe the hat says you're right on everything. We're on further discussion on the motion of ought to pass on House Bill 463. Is there further discussion on the motion of ought to pass on House Bill 463? Hearing none, the clerk will call the roll on the motion of ought to pass on House Bill 463.
Vice Chairman Quayle.
Yes.
Representative Perdomo O'Brien.
Yes.
Clerk says yes. Representative Wary.
Yes.
Representative Wood.
Yes.
Representative C.
Yes.
Representative Gosowski.
Yes.
Representative Sweeney.
Yes.
Representative Moffett.
Yes.
Representative Muirhead.
No.
Representative Ward.
No.
Representative Bay.
No.
Representative Grill.
No.
Representative Wilhelm.
No.
Representative Newsom.
No.
Representative Seibert.
No.
Chairman Barry.
Chair votes yes. The motion of ought to pass carries on a vote of 10 to 7. Representative Weary, you'll be responsible for the majority report. Who will be responsible for the minority report? I think I know. Representative Newsom, you'll be responsible for the minority report, which I will enjoy reading, I'm sure. Let me write that down fast. Okay. We will close the executive session on House Bill 463. Open the executive session on House Bill 590 relative to cooperative school board elections. I'll make the motion of ought to pass. Is there a second? Representative Quayle generously seconds. I will move amendment. Excuse me. Sorry. Get to my. Oops. Where's my amendment? 2934H. Where's my amendment? Sorry, I just wanted it in front of me before I move it. I thought it was right in front of me. 2934H. 2934H. Do you have 2934H? Is it not printed?
Don't have it handy.
Oh, we don't have copy. We may not have. Hold on. I'm gonna recess for just 30 seconds while I make sure we have printed copies of this amendment, because if we don't, we'll obviously get them. Okay, we're going to come back. We're going to need copies of that amendment. Obviously, we're not voting on an amendment that we don't have in front of us. That's unreasonable. I did send it. I didn't send it to HCS. I sent it to the vice chair and the ranking member. If I didn't send it to HCS, so let me take care of that. My apologies. Will anyone in the audience want a copy of this? Okay. 25. The good news is they're literally right next door. So, all right, we're going to recess 590. My apologies to the committee on that. We are on the motion of ought to pass. Going to open up the executive session for House Bill 686, requiring a voter to provide identification when requesting an absentee ballot. And I will recognize Representative Weary for the purpose of issuing a subcommittee report.
Thank you, Mr. Chair. The subcommittee reviewed House Bill 686, and at that time we voted to retain the bill and report that to the full committee. And I believe there's other actions to be done in this executive session.
Okay, is there further thank you, Representative Weary. I will make the motion of ought to pass on House Bill 686. Is there a second?
Second.
Representative Gosofsky seconds. I will move the non-germane amendment 2025-2935H to House Bill 686. Is there a second?
Second.
We're now on discussion of the amendment. I don't think I need to go over the non-germane amendment again. You probably all heard me talk for way too long earlier today anyways. So is there any further discussion on the non-germane amendment? Representative Muirhead, you recognize.
Thank you, Mr. Chair. I think it was conceded in testimony that certain public employees who had vital information about why a measure is on a ballot, such as a fire chief who might understand why a town needs to purchase a new truck, would be in technical violation of this electioneering law if they were to share those reasons in a town meeting. And it was said that the Attorney General would exercise prosecutorial discretion by not charging such a fire chief with violating the law, even though the fire chief had violated the law. And I don't think we should be placing our public servants in a situation where in the course of their ordinary work informing the public, they would be violating a law and depending on the judgment, I guess, of the Attorney General not to enforce the law. I just think that's not a good way of legislating. And so I think this could be refined and brought back in a future session.
Apologize, I didn't mean to step on you there. I hear that, except I think it has been refined at least 5 or 6 times. I've worked in pretty good faith to try to get this to a good spot. The reality is, it's never going to be perfect. There's no way to specifically say a fire chief can talk about a fire truck, but he can't talk about a library, right? There's no way to cut that down. The reasonable person standard, which is what this uses, it goes from an intent standard to a reasonable person standard. And Representative Muirhead, in the example you listed, a fire chief who gets up and says, people should vote for this new fire truck. The only reason he gets away with that, he is electioneering. He's electioneering under the current statute. The only way he gets away with that is because he's appointed by an executive body. So we say these public employees can electioneer, but these can't. So these special class of public employees, they can interfere in election all they want, But these public employees over here, no, they're held to a different standard. That's wrong. That's wrong. The public employees, every public employee should be held to the same standard. I believe that. I firmly believe that. I understand that you're not comfortable with the move from an intent-based legislation to a reasonable person standard. My point of bringing forward the AG is you have to think about what will happen. So if a fire chief or police chief gets up there and says, you know, we need this new fire truck, we need this new cruiser. The AG is going to have to prosecute. A jury is going to have to find him guilty, and a judge is going to have to allow the case, and a jury is going to have to find him guilty. It's not going to happen. I understand that you say it could happen, but you can make the argument it could happen now. You know, is it okay? Is it okay for the fire chief to tell firefighters to go door knock and tell people to vote for a warrant article? Is that okay? Does anybody here think that's okay if in their spare time he sent them around to do it? Of course not. Nobody here would believe that for a minute, right? You have to use a reasonable person standard to give that public employee the flexibility that they need to do their job. That's why I use a reasonable person standard. But you also have to recognize that there is grossly inappropriate behavior happening right now. It's not just about a survey. I have seen school districts put forth effectively propaganda videos for their incumbents that were running for re-election, where it did everything but say vote for this candidate. It happened to be they were doing profiles, and it was the Derry School District, Representative Pruitt O'Brien. They were doing profiles on their school board members, and they happened to start with every single one that was up for re-election. They went inside the school, and they filmed inside the school a highly produced video, and they released it. It didn't use the magical words "vote for," because so it didn't cross in the lines of express advocacy, which, by the way, under this new statute, by changing the definition of electioneering, which is what we're doing, it has to be express advocacy. That's in the statute. It actually uses the term express advocacy, so you have some built-in protection there. You had a case in Amherst, New Hampshire, with the school district, where the school district notified the parents on a Friday that on Monday the camera crews are coming through to film the school, and that their student might inadvertently be caught in the camera shot. What the superintendent didn't say was the Amherst voters had shot down the last 3 ballot initiatives for a new bond for the school to improve the school, and they were coming in to shoot a video. They were coming in to shoot a video to promote passing that warrant article. That's inappropriate. That's wrong. It doesn't matter where you stand on that issue. The government should not be putting its finger, public employees should not be putting their finger on the election. Obviously, on town elections, there's going to be a reasonable person standard held for this. There's no perfect legislation, but the games have to stop. And the only way the games stop is by improving the statute. Because when you have an intent-based statute, no one knows the intent in someone's heart. I hate intent-based statute. It's tough. Every now and then you have to use it, but you can't tell what's the intention of somebody. You have to try to pull it out from their actions. And it's just time that we address this. I think a reasonable person standard does this. It also, by the way, offers a $1,000 penalty instead of the misdemeanor. So that's an improvement. There's a lot of concessions and improvements on this. And I think getting hung up on one thing that will never happen, and it's certainly now well recorded in the legislative intent that a fire chief can talk about it. It's now well recorded in this rant. So it's just never going to happen. So, all right, with that, is there any other discussion on the non-germane amendment? Representative Seibert, excuse me.
So the way you kind of explained that, I get it. Wouldn't that negate the other bill that had passed through this year in regards to putting the per pupil cost alongside the test scores on the ballots? Like, isn't that electioneering of the same type you're speaking of?
It's not being done by a public employee. You know, the towns also send out the recommendation of their budget committee all the time. You know, these things happen.
Well, that seems to be a little electioneering to me. But it's not a little bit hypocritical.
It's not a ban on electioneering. It's a ban on electioneering by public employees while they are in the commission of their duties. They can say whatever they want when they're on their personal time. In fact, 98A protects them, and I believe in that protection. They can say whatever they want in their personal capacity on their personal page. They can go and hold signs out. That doesn't bother me. They can do whatever they want. But when they're doing their job, they're in their official capacity, they need to be neutral. They need to stay out of the political fray. That's what people want. That's what people want. Representative Muirhead.
Thank you, Mr. Chair. I'd like to note that I share your indignation about the examples of electioneering that you've described. For what it's worth, I also appreciate and acknowledge the good faith with which this language has been revised over the past year. And again, for what it's worth, the language having to do with polling and surveys, which is, I think, a core concern in the amendment, has been rendered in a form that I don't object to. Again, I don't necessarily expect you to be particularly complimented by that, but I thought it was problematic before, and now I don't. So I do really think I think it has been revised in good faith. I also think that this bill will very clearly make it illegal for instance, a police chief to explain to a town in a town meeting why a warrant article that would fund new armored vests is justified. We had to ask our police chief to explain that in a recent town meeting in Hanover, and they did, and as a consequence, against unfounded opposition, we were able to pass that warrant article. That kind of advocacy or explanation, I should say, in a public meeting would be against the law as this amendment is written. That we can trust the law wouldn't be enforced against the police chief is I think not a sufficient reason to pass this. A scrupulous police chief would refuse to break the law and would say to the town manager, I refuse to speak to this issue, because to do so would be to electioneer in a fashion that's against the law, and I won't do that as the police chief. Even though I trust that the AG won't prosecute me, I still won't break the law. And that would leave the town without the information it needs in the face of unfounded opposition to pass a warrant article to give the police force the armored vest that they need. So I think as much work has been done in good faith on this bill, more can be done, and we can make it right. And I think we have a responsibility to our public employees, in particular our police chiefs and fire chiefs, to get it right. And I think we can.
Sorry, if I could just respond to me for the mayor, then absolutely recognize. That's fine. Go ahead.
Thank you. I appreciate the effort going in to build the record on legislative intent, which I think kind of answers some of Representative Muirhead's concerns. But I think if we could fix that so that we don't have to have a court case go and argue legislative intent, if we can put that into the square four corners plain language of the document, I think that's where Representative Muirhead's concerns would be protected better and more efficiently.
So my response to that is, I've addressed the changes. Where's the language? Where's the language? The NEA's here, counties have spoken, the NHMA has spoken. Where's the language? Bring me the language that protects it. I'll put it in. Representative Muirhead, you mentioned, by the way, thank you for the kind words about the polling issue. I do appreciate it. I do take it as a compliment. Bring it forward. I'll put it in as a floor amendment. You know what my intent is on the bill. I would hope that most of you would agree with the underlying intent. Whether the specifics of it, I accept. There's differences. But if you want to bring forward language, this is the third iteration. I'm clearly open to making this agreeable to as many people as possible, but the games have to stop. So bring me forward language that's going to stop the games, and I will be more than happy to put it in. I've been very flexible on this to begin with, but my response to that is this is the third time we've handled this subject, so where's the language? Where's the language? Representative Wary.
If I could just address the fire chief example, as a member of the budget committee in my own town, I think there's a distinction between a fire chief or any public official who lays out the risk-benefit ratio or the pros and cons versus pure advocacy. And I think we're trying to avoid pure advocacy of a warrant article as opposed to laying out the pros and cons of a situation. Then at that point, if those pros and cons are laid out, it's up to the town or city ward to make that decision about the risk-benefit ratio to their community. But it's certainly in that case not pure advocacy, and I think we can be I think that is a factor in this whole reasonableness aspect. And so just wanted to add that comment. Thank you.
Representative Quayle is recognized.
Thank you, Mr. Chairman. I share what we'll call the unease regarding the use of a reasonable person standard in the statutes. It's all over the statutes. And I see it as a necessity. And my unease is based on the knowledge that reasonable people will differ in their conclusions, even given the same facts. But on the other hand, I don't see how human life, the world, human life, are too complicated to be able to specify the statutes to take care of every possible eventuality ahead of time. It just can't be done. And I don't believe we'd want to live in a society where that was attempted. So the alternative is a reasonable person standard. I don't see an alternative to that, especially in a case like this. So thank you.
Does anyone else wish to opine, or we've beaten this horse to death? All right. We will, hearing no other further discussion, we will take up the motion of adopting Amendment 2025-2934H to. Oops, I'm sorry. I'm reading the copies of the bill I just got. Oopsies. There we go. All right, 2935H to House Bill 686. The clerk will call the. Let's just vote on it. The clerk. Actually, do you care? The voice vote's fine, or do you want to? Voice vote? All right, we'll do a voice vote. All in favor of adopting the amendment 2935H, say aye. Aye. All opposed, say nay. Oh, okay. The opinion of the chair. The ayes have it. I will now make the motion of ought to pass as amended on House Bill 686 with Amendment 2025-2935H. Is there a second?
Second.
Representative Gosofsky seconds. We've beat this to death, but I will repeat my offer. Bring me language. I'll put it in a floor amendment if it's reasonable and accomplishes the objective. So advocacy groups out there that are watching this and tracking this, bring me the language. Hearing no other further discussion, the clerk will call the roll on the motion of ought to pass as amended on House Bill 686 with Amendment 2025-2935H.
Vice Chairman Quayle.
Yes.
Representative Pudomo Ryan.
Yes.
Clerk says yes. Representative Wary.
Yes.
Representative Wood.
Yes.
Representative C.
Yes.
Representative Gosofsky.
Yes.
Representative Sweeney.
Yes.
Representative Moffett.
Yes.
Representative Muirhead.
No.
Representative Ward.
No.
Representative Bay.
No.
Representative Grill.
No.
Representative Wilhelm.
No.
Representative Newsom.
Nope.
Representative Seibert.
No.
Chairman Barry.
Chair votes yes. The motion of ought to pass as amended on House Bill 686 with Amendment 2025-2935H carries on a vote of 10-7. I will be responsible for the majority report, and Representative Muirhead, I will look forward to your minority report. We will close the very spirited discussion on House Bill 686, which, by the way, thank you everybody for keeping it between the lanes, including mine. And then we will open up House Bill. Oh, actually, we're going to go back to House Bill 590 now that we have the amendment. My apologies. So we're going to resume House Bill 590 relative to cooperative school districts. I now have the amendment. We were on a motion of ought to pass. I will make the motion. I will move Amendment 2025-2934H. However, could that get confusing? Is there a second?
I second it.
Representative Quayle seconds. We're now on discussion of the amendment. This amendment came from the bill sponsors and the people over at House Policy. I was discussing with the, temporary ranking member yesterday of one of my objectives with the committee of this year was to try to get all election law bills through election law, including those that don't normally go to us. So this is one of them. So I do appreciate when we did the hearing. We were kind of all learning some new stuff that we don't normally cover. But this is the change that they said they needed to be made. It obviously just drops the last line to say a portion member of cooperative school board shall be reviewed and reapportioned if necessary based upon the latest federal decennial sentence and pursuant to RSA 159-19A. Is there discussion on the amendment? Yes, Representative Newsom.
How would this affect local control of existing agreements about how the cooperative school boards are allocated?
Yeah, well, it overrides it. But I think the issue is you have one man, one vote problems. And once again, as I kind of prefaced, I'm learning about this area of election law because we haven't handled my 5 years. We've never really handled this before. When reading this, I was actually stunned at some of the allowable operation agreements that the towns are allowed to enter into, because some of them so clearly violate one man, one vote, that I was not aware of any court cases when I was looking, but I was actually stunned that no one has brought one. So this will help that a little bit. But yes, to answer your question directly, obviously, we're telling people how they can form their school board, so that is what it is. Further discussion? Okay, hearing. Oh, sorry, Representative Muirhead.
I was wondering if you could just provide an example of that violation of one person, one vote.
Yeah. Well, so this one's talking about the apportionment, right? So kind of more broadly speaking, we've seen there are school district types where they elect their members from towns, but then everyone in the district gets to vote on who represents that town. So town A gets to tell town B who represents town B when that person's supposed to be coming from town B and representing town B. So that's an example of something that would violate one man, one vote. This is about the apportionment based on straight up population. So this is an attempt to kind of ease into that. Further discussion? All right, hearing none. Representative Muirhead, I apologize. Are you good with a voice vote on the amendment, or would you like a recorded vote? All in favor of adopting Amendment 2025-2934H, say aye. Aye. All opposed, say no. The ayes have it. I will make the motion of ought to pass. House Bill 590 ought to pass with Amendment 2025-2934H. Is there a second?
Second.
Representative Quayle seconds. Is there discussion on the motion of ought to pass as amended? Hearing none, the clerk will call the roll when she's ready.
Vice Chairman Quayle,
Yes.
Representative Pudom O'Brien,
Yes.
Clerk says yes. Representative Wary,
Yes.
Representative Wood,
Yes.
Representative C,
Yes.
Representative Kozowski,
Yes.
Representative Sweeney,
Yes.
Representative Moffett,
Yes.
Representative Muirhead,
Yes.
Representative Ward,
Yes.
Representative Bay,
Yes.
Representative Grill,
Yes.
Representative Wilhelm,
Yes.
Representative Newsom,
No.
Representative Seabird,
Yes.
sorry, and Chairman Barry.
Chair votes yes. The motion carries on a vote of 16-1. Okay, thank you. Thank you for
Chairman.
I was wondering if we were gonna have a real awkward moment.
What was my vote on that one?
I'm sorry, I had a 16. I had a yes.
Yes, I have yes.
Would you like to change your vote? I'll allow it if you'd like. The vote's technically occurred, but I'm fine without objection. If you want to feel you need to change
I
your
think
vote.
I would.
Okay. So we'll go down to a 15-2. Are you still okay with the consent calendar, or are you going to object to the consent calendar too?
That's fine.
All right. So we'll be reported out as 15-2, with the courtesy of not redoing the vote. So no member has an objection to not redoing that vote, right? All right. So we're going to move forward. All right. We're going to close the executive session on House Bill 590, and we just did 686. I'm doing the report. Sorry. We will open up the executive session for House Bill 693 relative to ballot counting procedures and permitting the hand counting of ballots. I'm making the recommendation. I will move any expedient to legislate on House Bill 693. Is there a second? Bueller? Representative, you can't. Representative Newsom seconds the motion. I'll speak to the motion. We've already passed this bill, so we can just kill it. There you go. Further discussion on the motion of any expedient to legislate on House Bill 693. Hearing none, the clerk will call the roll on the motion of any expedient to legislate.
Vice Chairman Quayle,
Yes.
Representative Pudom O'Brien,
Yes.
Clerk says yes. Representative Wary,
Yes.
Representative Wood,
Yes.
Representative C,
Yes.
Representative Kozowski,
Yes.
Representative Sweeney,
Yes.
Representative Moffett,
Yes.
Representative Muirhead,
Yes.
Representative Ward,
Yes.
Representative Bay,
Yes.
Representative Grill,
Yes.
Representative Wilhelm,
Yes.
Representative Newsom,
Yes.
Representative Seibert,
Yes.
Chairman Barry.
Chair votes yes. The motion carries on a vote of 17-0. Any objection to the bill being placed on the consent calendar? Hearing none, the bill will be placed on the consent calendar. We will close the executive session for House Bill 693. And I will write the world's shortest report. Going to open the executive session for Senate Bill 44 FNL relative to hand count ballots at elections. And going to recognize Representative Perdue O'Brien for a motion.
I move ITL.
Is there a second?
Second.
Representative Wood seconds. Representative Perdue O'Brien, would you like to speak to your motion?
Same thing. This is already covered elsewhere.
Okay. Is there any further discussion on the motion of any speaking to legislate on Senate Bill 44 FNL? Hearing none, the clerk will call the roll.
Vice Chairman Quayle,
Yes.
Representative Perdue O'Brien.
Yes.
Clerk says yes. Representative Wary,
Yes.
Representative Wood,
Yes.
Representative C,
Yes.
Representative Kozowski,
Yes.
Representative Sweeney,
Yes.
Representative Moffett,
Yes.
Representative Muirhead,
Yes.
Representative Ward,
Yes.
Representative Bay,
Yes.
Representative Grill,
Yes.
Representative Wilhelm,
Yes.
Representative Newsom,
Yes.
Representative Seibert,
Yes.
Chairman Barry.
Chair votes yes. The motion of any speaking to legislate from Senate Bill 44 carries on a vote of 17-0. Is there any objection to the bill being placed on the consent calendar? Hearing none, the bill will be placed on consent calendar. Representative Perdue O'Brien, you'll be responsible for the committee report. We're going to close the executive session for Senate Bill 44. I'm going to open the executive session for Senate Bill 103 FN local relative to the number of polling locations that are available for certain towns. I will make the motion of ought to pass. Is there a second?
Second.
Representative Quayle seconds. Let me get the amendment out. We do have an amendment. Find it out. Where did it go? I know I have it. There it is. All right. I will move amendment 2025-2938H. Is there a second? Representative Quayle?
Second.
Thank you. We're on discussion amendment. The amendment doesn't substantially change the bill in any real way. So you're probably asking why I did that. The Senate wants to take another look at this bill. I liked the concept. I didn't want to kill it and restart it. So I made changes that were basically purely grammatical. So if you find something that is an actual substantive change, please let me know, because it certainly was not my intention. But we still need to have a fervent discussion on the actual underlying issue. But that's the purpose of the amendment. In full transparency, I want to send it back to the Senate one more time. Representative Muirhead.
Does the amendment make the grammar better or worse?
Well, I would hope it makes it better, but I cannot guarantee that. A reasonable person cannot guarantee that. Further discussion on the amendment. Hearing none, Representative Muirhead, are you comfortable with a voice vote on the amendment? All in favor of adopting Amendment 2025-2938H, say aye. Aye. All opposed, say no. In the opinion of the chair, the ayes have it. I will make the motion of ought to pass as amended on Senate Bill 103 with Amendment 2025-2938H. So now we should discuss the bill.
Second.
Second, thank you, Representative Quayle. We should discuss the bill because it is substantive. So in presidential elections only, this bill requires that towns with more than, for every 15,000 registered voters a town has, they have to either have a second voting location or they have to go through the SOS and get approval. It doesn't affect that many towns. There are certain towns that handle one polling location very well. Derry is actually one of them. Pinkerton Academy does a very good job of gets the nation's largest polling location, and Pinkerton Academy does a very good job of getting everybody in, everybody out very quickly. So my hope is that the Secretary of State would say, Derry, keep doing your thing at Pinkerton. You're good to go, no problems. There are other towns that are not so great at it that have one polling location. Londonderry and Bedford when you look at the number of registered voters from the latest report from the Secretary of State in August, are the only 2 towns that I saw that have more than 15,000 registered voters that are only using 1 voting location. So these are the only 2 towns right now that are affected by the current language. I can tell you from personal knowledge, I went to Bedford and I went to Londonderry in this last election, and I was pretty just bluntly appalled at what I saw. It took me, I think, 45 minutes to get to Park in Bedford, and I obviously wasn't voting there, right? And then so it's 45 minutes to then get in line. That's unacceptable. That's unacceptable. It's just unacceptable. There's really just, I'm sorry, there's just no excuse for it. It's unacceptable. Lines, consolidated voting locations, have been used by nefarious actors in other states to try to suppress votes. I'm not saying it's what's happening in Bedford and Londonderry, for the record. But you have to be cognizant that that's a thing. I believe the federal standard is you have to be in and out in 45 minutes. Somebody might correct me on that. But I believe there's a federal standard that says how quickly you have to be in and out of a voting location on a federal election. So this would force Bedford and Londonderry's hands to do something. They either need to fix their current process and get people in and out quicker, or they need to open up a second location. That's what the bill does. So that's the intent of the bill. If you've been on this committee before, you've heard me give a very similar speech to that. I hate lines on election day. I will always hate lines on election day, and there's nothing you're going to tell me that lines on election day are okay. Any other comments? All right. Well, that was cool. We're on the motion about to pass as amended on Senate Bill 103 FN local on with Amendment 2025-2938H. The clerk will call the roll.
Vice Chairman Quayle.
Yes.
Representative Pudomo Ryan.
Yes.
Clerk says yes. Representative Wary.
Yes.
Representative Wood.
Yes.
Representative C.
Yes.
Representative Gozowski.
Yes.
Representative Sweeney.
Yes.
Representative Moffett.
Yes.
Representative Muirhead.
Yes.
Representative Ward.
Yes.
Representative Bay.
Yes.
Representative Wilhelm.
Yes.
Representative Newsom.
Yes.
Did I miss one here?
Yeah.
I did?
Sorry.
Representative Grill. My apologies.
I'm yes.
Okay. And Chairman, Representative Seibert.
Yes.
Chairman Barry.
Chair votes yes. The motion about to pass as amended with Senate Bill 103 FN local carries on a vote of 17-0 with Amendment 2025-2938H. It cannot go on the consent calendar because it has a fiscal note. So you'll hear a very similar speech that I just gave on the floor, and I will handle the report. I have to get out of here. It's good seeing you all. I hope you all had a great, amazing. We're going to close the executive session, and I hope you all had a great, amazing summer. I hope you have a great, amazing fall. If I don't see you, and I'll see you guys in January.